Hey there, fellow citizens. Welcome back to another enlightening episode. In this video, we're diving into the murky waters of contract law, specifically those pesky things called exclusion clauses. These are the hidden traps in contracts that can catch you off guard. Don't worry, we'll keep it simple and straightforward so you can understand without needing a law degree. In plain English, an exclusion clause is a bit in a contract that says a company isn't responsible for something, even if it's their fault. These clauses are often used to limit liability. Think of it like a get-out-of-jail-free card, but for businesses. They can avoid responsibility for certain issues. These clauses can be sneaky, often hidden in the fine print of contracts we rarely read. It's like finding a needle in a haystack, but they can have a big impact, especially if things go wrong. Imagine signing something without knowing what you're agreeing to. So next time you're signing something, keep an eye out for these clauses. Read carefully and ask questions if you're unsure. Knowing what they are is the first step to not getting screwed. Stay informed and protect yourself. Let's bring these exclusion clauses to life with some real-world examples. They are more common than you might think and can be found in many everyday situations. Imagine you park your car in a multi-story car park, a place you visit often without much thought. You see a sign that says, "Not responsible for loss or damage." It's a small sign, but it carries a big message. That's an exclusion clause in action. It means the car park owners are not liable for any damage or theft. Or say you buy a new phone and the warranty says it doesn't cover water damage. You might not notice it at first, but it's there. Yep, you guessed it, another exclusion clause. This one protects the manufacturer from certain types of claims. They're everywhere, lurking in contracts for gyms, airlines, and even in the terms and conditions of your favorite online stores. Yes, even your favorite online stores have them hidden in the fine print. These clauses can feel unfair, especially when something happens that's clearly not your fault. They can be frustrating and confusing. But remember, businesses use them for a reason, which brings us to our next point. They help manage risk and protect against potential losses. Businesses, especially big corporations, love exclusion clauses. Why? Because they limit their financial risk and provide a safety net against unforeseen liabilities. Think about it, if a company didn't have these clauses, they could be sued for almost anything, leading to potentially devastating financial consequences. A customer could sue a restaurant for a bad meal, claiming it caused them harm, or someone could sue a gym for a sprained ankle, arguing that the equipment was faulty or the environment unsafe. By using exclusion clauses, businesses can protect themselves from some of these claims, ensuring they remain financially stable. This allows them to keep their prices lower and avoid costly lawsuits, which can be a significant burden. However, there's another side to this story that we must consider. While exclusion clauses can benefit businesses, they can also put consumers at a disadvantage, leaving them with little recourse in case of genuine grievances. The two sides, good and bad, of exclusion clauses. Like most things in life, exclusion clauses have both pros and cons. For businesses, they offer protection from frivolous lawsuits and help keep costs down. But for consumers, these clauses can feel like a raw deal. They can limit your rights to seek compensation if a company is negligent or provides a faulty product or service. This is where things get tricky. The law tries to balance the interests of businesses and consumers, but it's not always easy. The legal showdowns when exclusion clauses go to court. Over the years, there have been numerous legal battles over exclusion clauses. Courts have struck down clauses deemed unfair or unreasonable, especially those that try to exclude liability for serious negligence. One famous case involved a dry cleaner who tried to exclude liability for damage to a customer's dress. The court ruled the clause unfair, as the dry cleaner was in a better position to insure against such risks.